Hello everyone, I am Rusha Mukherjee, a student of Students at Law College, interning with LEXIS and Company. Today I am going to talk about the right of internet as a fundamental right. For it, we know that each and every things we do are completely dependent on internet today. The digital world has taken our lives a lot forward. We are depending for our work, for our jobs, for the education, everything we are dependent for the right to internet. If internet is suspended, all the other rights are hampered together. For this purpose, in 2016, the United Nations Human Rights Commission had declared the human rights as the right to internet as the basic human right and wanted it to be termed as a fundamental right. Earlier also it wanted to turn another right into fundamental right, and that was the right to education. And now the right to internet was very important, and hence it should be turned a fundamental right. Coming to the Indian scenario, in the last 10 years it has been found that more than 400 internet shutdowns have taken place. If we talk about the Jammu and Kashmir incident where Article 370 was revoked, there was a lot of unrest in Jammu and Kashmir, and due to that, on 4th August 2019, the internet was shut down for an indefinite period, and Section 144 was imposed that prohibited the assembly or gathering of more than 5 people. It was one of the longest internet shutdown in India. It went to 213 days. Ultimately, it was again restored on 4th March 2020. In the meanwhile, there 3 cases came. The first case was Fahima Shireen versus the state of Kerala. Here, Fahima was a college student, and in her hostel, the internet service or the mobile use was banned from 6 to 10. She actually filed a case against this practice of the hostel, this rule of the hostel. Here the courts said that right to privacy and right to internet and right to education all are very much interlinked. Our right under Article 21 constitutes the right to privacy, and a person cannot be denied so. And it is also related with Article 21A or the right to education. And disallowing a college girl from accessing internet for a certain time will actually hamper her studies, and so this was an unfair practice and cannot be done. The second case was where the Anuradha Bhasin versus Union of India. In this case, the Supreme Court said that due to immediate threat or security concern, a temporary ban of services can be given, but it cannot be for an indefinite period. And it also told that a balance should be maintained between national security and the rights of individuals. Next came, after this incident, that the 2G internet was allowed, very slow speed internet was allowed in Jammu and Kashmir. Then came on 10th January the next case, that was where it said the 4G internet disallowance is actually violating many of the rights like right to education, right to profession, and right to health, and many other related rights. The case was named as Foundation of Media Professionals versus Union of India, or the 4G case. Here the Supreme Court issued directions to resume 4G internet, and a committee was set up for that. After much discussion, it was decided to be restored to specific areas from 15th August. Then it was actually understood by the Supreme Court's verdict that in the present era, where we have nothing to do without the internet and the entire nation is going into digitalization, like Modi has said that we are heading towards a digital India, and in this scenario, a shutdown of the internet is not at all permissible. The Kerala state government, after the verdict that was given by the Kerala High Court, has actually provided internet services to people at a subsidiary rate so that everyone can access it. And hence, Article 21 also incorporates within itself the meaning of right to internet in these times. That's all for today. Thank you, goodbye, and have a nice day.